Hi, my name is Kyle Melling, and I'm one of the attorneys here at Lowe Scott Fisher. An issue that has risen to the forefront of all of our minds is how our clients manage their social media accounts after they have been injured or in an accident. In 2021, it is not only completely normal, but in many ways it is now expected that we will post all over our various social media accounts about significant events that occur in our lives. This includes not just the good events like birthdays, weddings, or vacations, but also the negative events, including if you've been injured in an accident. But the old adage is very true. Nothing you post on the internet or on any social media site is truly private, and you should give serious consideration prior to posting anything on the internet or on social media about an accident or an injury. We warn our clients all the time that you should assume that anything you post on social media after an accident can and will be reviewed by the defense in a lawsuit and will become an exhibit in your deposition and in your trial. Because of this, today I'd like to point out a few rules to consider with regard to social media after you've been in an accident or injured. First, and most importantly, do not delete anything that you've already posted, but do adjust your privacy settings. You absolutely cannot delete anything that you've posted so you don't spoliate any evidence. If you have deleted something off your social media pages after your accident, it's very important to let your attorney know. What you can do, however, and what we recommend that you do, is use the privacy settings on all of your social media accounts and set them all to completely private. This way, only those who you have given approval to can see what you post. This does not protect your posts from discovery when we're in litigation, but it does stop investigators from insurance companies and defense firms from investigating your social media accounts prior to filing a lawsuit. Here at Lowe Scott Fisher, we are all very experienced in privatizing social media accounts, and we can point our clients to resources on how to effectively do this. Rule number 2, resist the urge to post about your accident. I know that the tendency in this world is to use social media to share with friends and family major life events. Resist this urge. A year or 2 years later, when you are in a deposition or you are at trial and you're trying to convince a jury that you were indeed injured in this accident, your quick social media post that said, "Hey everybody, I was just in an accident, but don't worry, I'm okay," is exhibit number 1 that the defense uses to show that you weren't actually that hurt. Rule number 3, once a lawsuit has been filed, avoid creating new posts in general. Many times our clients are very surprised in a deposition where they testify that they're perhaps unable to travel or it's difficult for them to travel due to the injuries they sustained in the accident. And then the defense attorney hands them a photo from their Instagram account from last week showing them on a plane or on a beach. We all know that social media is not real life. It's a curated version of the best form of ourselves that we post online for others to see. But in the hands of the defense, these type of hand-picked, curated photographs are pure gold to tell a jury that you weren't actually that injured. They say, look how much fun you were having on that vacation. Rule number 4 is similar to rule number 3. Encourage your friends and family to avoid posting and avoid tagging you on social media. Just like we don't want you posting that curated version of you living your best life, we don't want your friends and family tagging you on that vacation where you were on the Vegas Strip 2 weeks after your car accident. That post shows you having the time of your life and shows you not having a care in the world. What that post doesn't show is the discomfort or the pain that you might have been in, or the repeated trips to the doctor or physical therapist to get recovered enough so that you could go on that trip. But in the eyes of the defense and ultimately the eyes of the jury, that discomfort and that recovery is not presented in those photographs. So when in doubt, don't post. This applies not just to posts that you make, but also posts that your friends and family make where they tag you. Rule number 5, this extends not just to social media, but it's also something you should consider with regard to text messages and emails. Do not use the direct message features or the private message features of social media to send messages about your case, about your accident, about your injuries in general. These messages, even though they are private, can be subject to discovery in some circumstances in litigation. This is an extreme example. It does not happen in every case. But just err on the side of caution and don't send those messages about your case, about your injuries, about your accident using social media, private or direct messaging, or text messages, iMessages, or emails. Rule number 6 is 2 parts. First, we do understand that there are many people and many times when it is impossible to avoid posting on social media. Many of our clients use social media for their jobs, whether they are marketing professionals or Instagram influencers. The important thing is, discuss this with your attorney. Make sure your attorney knows what social media you use, and if you have to use it for any reason, check with them first. Second, make sure up front you inform your attorney of all of your social media accounts, including those where you don't use your real name or your likeness. All of those accounts can become discoverable in a lawsuit, so it's essential that your attorney be aware of them so that we can be prepared for any requests that might come from the defense once we file suit. Finally, and I know this one's tough, but consider taking a break from social media entirely during the pendency of your injury claim. I think we can all agree as a society we spend collectively too much time on social media. You can think of this as an opportunity for a reset. Being in an accident and/or getting injured can be a really traumatic experience. Use this time to focus on your physical and mental health as you recover. I hope these rules and guidance are helpful. If you need to consult with an attorney for any reason, please feel free to contact myself or any of the attorneys here at Lowe Scott Fisher. Thank you.